All right. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Good morning, everyone. We appreciate all of y'all being here. I don't know that the attorneys realized that we were going to have quite such a big audience. They're here to hear all your arguments today. We are here on the case, just a normal kind of situation for the students that are here, the law clerks. We have oral arguments every month for usually around the first week of the month. So if you want to come back sometime, please do. We always enjoy having people here. We also have a YouTube channel where we live stream, and we also have all of the videos of other oral arguments. If you're getting ready to prepare for one, it's always good to go through and watch some of those. But you've got really good lawyers here today, really good briefing. We have briefing from amicus too. So an interesting case with some interesting issues that actually would be very pertinent to you in your practice, no matter where you are, what kind of walk you take in as a lawyer. So, Madam Clerk, if you'll call the case.
Case number SC 2025-0918, ex parte State Farm Fire and Casualty Company. This is a petition for a writ of mandamus to the Bullock Circuit Court. Arguing for the petitioner, the Honorable Sarah Rawls and the Honorable Will Courtney. Arguing for the respondents, the Honorable Frank Wilson.
All right, so everybody ready? Ms. Rawls?
Good morning, and may it please the court. Sarah Rawls, along with Katie Powell and Abbott Jones for petitioner, State Farm. The order at issue is called a protective order, but it doesn't actually protect State Farm's confidential and trade secret materials. There are two primary problems with this sharing order. First, the order allows State Farm's proprietary materials to move beyond this case in a way that turns protection into distribution in violation of this court's precedent. Second, the order infringes upon the ability of other trial courts to exercise their own Rule 26 discretion. Turning to the first point, this court established in Ex parte W.L. Halsey that confidential and trade secret materials must be protected to the maximum extent practicable. Ex parte Miltope teaches that a protective order is not adequate, where its structure creates a risk that proprietary materials leave a controlled environment. This sharing order violates those two principles here, so long as the plaintiff's counsel in this case add their names to another bad faith roof case against State Farm. They can share State Farm's confidential and trade secret materials with other attorneys. But the sharing order does not require that the plaintiff's counsel in this case actually make sure that downstream attorneys see a copy of the order or agree to be bound by it. The sharing order also doesn't require that plaintiff's counsel in this case actually track or monitor who all receives what information downstream. Now, State Farm's proposed protective order included these requirements, but the trial court did not include them in the final order. The sharing order also doesn't realistically subject downstream attorneys or governmental agencies to any return or destroy obligations. That is not protection, that is distribution. Turning to the second point, the order infringes on other courts' ability to exercise their discretion. Rule 26 of the Alabama Rules of Civil Procedure ties discovery to, quote, the pending action, end quote. The 2018 committee comments also confirm that a trial court's decision about the scope of discovery has to be, quote, case specific. The sharing order completely circumvents the Rule 26 process. This is where ex parte mobile infirmary matters. A protective order cannot and should not be used as an end run around the rules governing discovery. In that case, the end run was around the medical malpractice statutory discovery limit. Here, the end run we're dealing with is around Rule 26's case-by-case process and the authority of other courts to manage discovery in their own cases. There is a concrete example showing this problem. Keep in mind that 2 federal judges in Alabama have already rejected plaintiffs' same sharing request. One of those judges, Judge Dinella, considered an almost identical motion to compel documents as the trial court did here. Judge Dinella, like Judge Smithart, exercised his own Rule 26 discretion based on the facts of the case in front of him and found that the same documents were not discoverable. If the sharing order is allowed to stand, it will effectively undo Judge Dinella's ruling and allow documents he said had no place in his case to be inserted anyway. If the sharing order is allowed to stand, it will mean that plaintiffs' counsel, at their sole discretion, get to decide where discovery goes before other courts get to make their own rulings about relevance, proportionality, the needs of that pending action. And it will deprive other defense counsel across the nation of the opportunity to oppose what gets inserted in their cases.
So I wanted to ask you about the government sharing provision. As I understood the plaintiff's brief, they seem to argue that your proposed order that you gave the judge would allow the sharing with the government just like the order that the judge entered. So are they correct, or is there something different?
That is not correct, Your Honor. State Farm's standard non-sharing order does allow for documents to be shared specifically with the Alabama Department of Insurance, but no others. Plaintiffs goes much broader than that. It just says governmental agencies who have oversight authority. That is a much more expansive version of governmental agencies. I think Judge Proctor referred to that as the ominous reference. What does that mean? And in addition, as it relates to governmental agencies, they are not required to be bound by the protective order. They are not subject to return or destroy obligations.
So would your proposed order have made the Alabama Department of Insurance bound by a return or destroy provision?
To the extent they received confidential information, I believe that there would be a requirement that someone from the agency sign Exhibit A, which is attached to State Farm's proposed order. What we have in the sharing order is really no one is required to sign Exhibit A, and that's the problem we have here.
Would they be able to give it to the Department of Insurance in Alabama under your proposed order without a subpoena and without the Department of Insurance asking?
I believe that would be accurate. I would defer to the specific language in the order, but that sounds correct. I want to pause and note for a moment that State Farm is simply asking this court to apply already existing Alabama case law and Rule 26. It is plaintiffs who are advocating for an exception to how discovery and protective orders typically work, but without any binding Alabama law or rules to support or justify that exception. At most, what we have to date are policy arguments from plaintiff. For example, this idea that sharing is somehow needed in this Bullock County action because it makes other litigation not before the Bullock County trial court more efficient.
So the other cases that are pending, they have, I think, do they have 8 more cases in Alabama?
Approximately 8 other cases, yes, sir.
Are they identical cases? I mean, different plaintiffs, but basically the same allegation pasted and blocked.
While they do share similar allegations, the facts differ, and Rule 26, of course, deals in facts. And I'll note that there was nothing before the trial court supporting this idea that other litigation would become more efficient. For example, plaintiffs did not provide the trial court with any specific factual information about the other cases, about how they were proceeding, much less enough information for the Bullock County trial court to conclude that the other litigation would become more efficient. And Judge Proctor also spoke to this when he separately rejected plaintiff sharing request, and the comment was something to the effect of, Why is it my role to, quote, solve all the world's problems, end quote, in other cases, when he didn't have an understanding of what was going on in those cases? But that's exactly what happened here. One trial court.
But you would oppose this sharing order even if it was limited to these existing cases in Alabama that have identical allegations?
We would, Your Honor, for a couple of different reasons. First, again, there is no record showing of need. That other litigation would become more efficient. No record evidence that the cases are so similar or identical. It's important to keep in mind, this is not a products case. This is an individual insurance action. There are different dates of loss, different geographic locations of properties, different guidelines depending on the date of loss. I could go on. I would also say that we still have the problem, the core Miltope problem of probable dispersion. State Farm's proprietary materials would still be inserted into other cases, to other courts, to other experts.
So would you be okay with, going back to the first point you made, would you be okay with a sharing provision of some sort if there was some kind of hearing in this case about the facts of these other cases and it turned out they were identical? Would that be something you're saying would be okay, or are you just saying leave it to the other cases?
No, Justice McCool, we would not find that sufficient. At its core, we still have the problem that one court is basically deciding what gets inserted into other cases. State Farm's point is that discoverable in case A does not mean freely transferable into cases B, C, or D, because of course those courts still get to decide relevance, proportionality, needs of that case.
So to your second point about the probability of dispersion, should it make any difference in our analysis that in Miltope, for example, that involved if I understand it right, that involved a competitor there was going to be disclosure directly to someone working for a competitor and I don't think there's any dispute about that here. There's no competitor directly involved, right?
That is correct, Justice McCool.
So should that make any difference in our analysis here? Should Miltope be distinguished in that basis?
It should not make any difference, Justice McCool. Miltope did not turn only on the fact that plaintiff worked for a competitor. The court's broader concern in Miltope was that proprietary materials could leave immediate litigation in a way that can't be monitored, tracked, or enforced. In other words, once they leave that case, the proverbial bell can't be unrung was the language they used. That same rationale applies here, and actually even more strongly. At the moment of disclosure under this sharing order, State Farm's proprietary materials could move to other downstream attorneys, to governmental agencies, and really others whose identities and uses cannot be fully known. That is precisely the probable dispersion.
I'm sorry.
Miltope was concerned about.
I'm sorry. But you keep talking about the government agencies, but your State Farm's proposed order included language to make the information available to the Department of Insurance, law enforcement officers, and other government agencies.
Yes, Your Honor, it did.
Now you're objecting to that.
And I appreciate the opportunity to clarify. What we are objecting to is the dispersion to an even broader range of governmental agencies that really isn't even defined. And so at the moment—
But your proposed order didn't define it. It says, or to other government agencies.
The order that State Farm proposed is certainly defines the Alabama Department of Insurance as one of them. And to the extent there are others, the others that plaintiff might propose sending them to, there would be additional safeguards there. So for example, the monitoring and the tracking, the subject to return or destroy obligations that just aren't present here.
To shift just a second, though, it seems that the Judge Smithart's order, and the pages aren't numbered. I think it's probably page 2 at the very bottom. There may be a tense argument about whether the plaintiff's attorney, if we're going to do a sharing order under Judge Smithart's order, if the sharing is with clients currently represented by the plaintiff's lawyer versus prospective clients in the future. And I'm sorry, I didn't realize your light was on.
If I may
Go ahead,
answer your
Justice
question.
Nunham, and finish your question. And let Ms. Rawls.
Question out if you remember it or if I stated. You understand what I'm saying?
I will try my best. If I get off kilter, you're welcome to bring me back. So
I'm sorry, okay, it says, all such materials furnished shall be available to counsel for the requesting party to use in this case and in any cases in which counsel for the Foors also represent parties that have made claims in bad faith against State Farm relative to a roof claim.
even
Be prospective, would it?
potentially not, even if we're just looking at current cases, current pending cases, based on the text of the order Your Honor just read, we still have cross-case sharing. It is not limited to a fixed set of attorneys or cases or jurisdictions. So the probable dispersion that we're dealing with,
Counsel for the Foors.
it said, yes, Your Honor, the order says that State Farm's confidential and trade secret materials can be used or are available not just for use in this case, but, quote, in any cases in which counsel for the Foors also represent parties with bad faith. All that is needed is for plaintiff's attorneys in this case to simply add their names to another pending action through a pro hoc or through the licenses already existing.
I'll start with the red light, but it says also represent parties that have made claims. So if you've not made a claim in the Foors counsel,
Whether it's pending or prospective cases, the dispersion we're looking at under this order without the tracking and monitoring safeguards, without the return or destroy obligations is still the probable dispersion that Miltope was concerned about.
I'll let you go with the red light. Thank you, Chief.
Okay. Ms. Rawls, thank you. Madam Clerk, if you'll add the extra time to Mr. Wilson's, please. Mr. Courtney.
May it please the Court. My name is Will Courtney, and I represent AMICI, the U.S. Chamber of Commerce and American Tort Reform Association. The Alabama Rules of Civil Procedure do create two mechanisms for sharing discovered materials between plaintiffs. Those are class actions under Rule 23 and consolidation under Rule 42. But there's no basis in the rules for giving plaintiffs upfront permission to share discovery with unknown future plaintiffs in other collateral cases. Sanctioning that approach would undermine the valuable trade secrets of any company that could find itself a defendant in Alabama State Court, making this state a much riskier place to do business. The Court should grant State Farm's petition. With my limited time, I'd like to briefly describe 3 features of more tailored approaches to discovery sharing from other jurisdictions. The upshot of this is that a decision in this case prohibiting this kind of upfront sharing provision will not prevent the Court from permitting sharing in a more manageable way in the future. The Court could still look to other jurisdictions and adopt a discovery sharing framework where, 1, plaintiffs in collateral cases may intervene to seek modifications of protective orders. 2, courts considering those modification requests apply a presumption against modification. And 3, any modifications preserve the independent discovery authority of collateral courts. So first, the proper way to add a sharing provision to a protective order is not to authorize sharing up front, but to modify the protective order in the event a concrete need for sharing arises in the future. Federal courts overwhelmingly favor this kind of modification approach, and in federal court, it's achieved by filing a motion for permissive intervention under Rule 24B. Alabama's Rule 24B is equally suited to that purpose, and the court could point that out as a vehicle. 2, when a court considers whether it should modify a protective order to allow sharing, it should apply a presumption against modification and then assess whether that presumption is overcome by the collateral plaintiff's extraordinary circumstances or compelling need. The strength of that presumption should be determined based on the nature of the protective order and whether it invited reasonable reliance. So in cases like this one where the parties negotiate a protective order and contemplate specific confidential materials to be covered, that should be entitled to a strong presumption against modification. And finally, 3, if a court decides to modify a protective order to permit sharing, it must do so in a way that defers to the collateral court's ability to also run its own cases. The purpose of modification is just to remove a barrier to sharing, not to usurp another court's authority by resolving disputes about the ultimate discoverability of documents in other cases before that court. So if this court, in this case or later, endorses a modification-based approach to sharing, it should also make it clear that any modifications respect the collateral court's ability to decide whether any documents proposed to be shared should ultimately be shared. If there are no questions, I will conclude and ask the court to grant the petition. Thank you.
Your comment in your brief that amici do not doubt the shared discovery sharing may be appropriate in certain circumstances. Can you explain to me what you meant by that?
That refers to the viability of this modification-based approach. So we don't think that it is ever appropriate at the beginning of a case to give plaintiffs license. Whatever they want to do in other cases is fine. But there are surely circumstances where plaintiffs from an ongoing other case can come, make a good showing, and some reasonable sharing arrangement could be worked out. All right, thank you.
Thank you, Mr. Gordon. Mr. Wilson?
Chief Justice Stewart, may it please the court, I'm Frank Wilson and I represent the Foors today. I stopped counting at 8 the number of times that counsel referred to this as a sharing order. It is not a sharing order. We asked for a sharing order. We didn't get a sharing order. I think it'd be a good idea to look at the order we did get. It allows us to share these documents with ourselves. I provided a old-fashioned blow-up for the court, copies for the court. We are allowed to use these documents in cases in which we are counsel. How they're used by other courts in other cases is not really a subject of this order. We are limited to those cases in which we have made an appearance. If we make an appearance, State Farm knows we're there. State Farm knows we have.
Can I ask you to follow up on the previous discussion I had? Under Judge Smithart's order, do you agree with the assertion that you could then go and that you could enter an appearance or your co-counsel in a case in California, and suddenly that brings in all these documents?
Well, two things. First of all, we're only getting documents that relate to State Farm's Alabama operation. Not only is the order.
So you're saying you do not believe Judge Smithart is permitting you to go enter an appearance tomorrow in a State Farm roof case in California and take these disputed documents with you into that case?
I agree with you, your prior comment that it is somewhat ambiguous to that extent. But my understanding would be that he would allow us to use, that's a difficult word to make fit here, but to use these documents in any case where we made an appearance.
Into the future, you're saying?
Yes.
You would not ask Judge Smithart to clarify that before you did it?
I'm sorry, I didn't hear.
You would not ask Judge Smithart to clarify that point before you did that? Because again, the same language that I quoted earlier, there seems to be a tense issue. It appears to be page 2 of Judge Smithart's order. They're not numbered. All such materials furnished shall be available to counsel for the requesting party, that's you and co-counsel, to use in this case, that's the Foor's case, and in any cases in which counsel for the Foors also represent parties that have made claims in bad faith against State Farm relative to a roof claim. So seems like we're looking at is parties that have made claims. You don't think you should ask Judge Smithart before you did that prospectively in the future?
Let me say this. I'm going to do anything that needs to be done not to run afoul of Judge Smithart's order.
Do you read that as saying that you can't, as what State Farm is alleging, that you have carte blanche now to go anywhere in the country and simply enter in your appearance and disclose, at least within the context of a protective order to counsel?
First, let me say this. That assumes or certainly implies that we're going to try to make some kind of end run on this order that Judge Smithart has entered.
That's what State Farm is saying. So
Well,
I need you to respond to that.
I'm discouraged that State Farm doesn't begin with the assumption that the lawyers that practice before this court are ethical.
I don't view them as accusing anyone of being unethical. We're all lawyers and words mean something. And I'm trying to figure out if both sides are in agreement that these words mean that you can go forward in other cases in other jurisdictions or you cannot.
Well, let me address it as if it does allow us to do that. There's one thing in this order that I think both sides agree on. We asked for a sharing order. In our sharing order, we included a provision that anyone with whom we share a document must agree to be bound by that protective order and submit themselves to the jurisdiction of the Alabama courts. That order was apparently unintentionally, that provision did not make its way into the order. We will ask Judge Smithhart to include that in the order. We'll stipulate here, if that's a better procedural way of doing it, that provision that they must subject themselves to the court be included in the order. I think it was just an inadvertent omission, but I think that is critical, and that's why, with that included, I don't think there should be a concern that courts elsewhere might, lawyers elsewhere might have an opportunity to abuse the order.
Mr. Wilson, could I direct your attention for a minute to the language of Rule 26?
Yes.
I'm going to sort of skip over some words, so feel free to supply anything that I'm missing that you think is important. But it says that parties may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action. And then I'm going to skip over some words. It also says, and proportional to the needs of the case. My first blush reading of that is that the scope of permissible discovery really is set up by that provision of Rule 26 to pertain only to the matters within the case that is brought. In other words, Foor versus State Farm. And then the language about the protections for trade secrets comes later, all as an outgrowth of that original scope limits. I guess my question is sort of how do you see that language as affecting your position, even as to the cases in the narrow universe of case that you're just trying to describe about the ones where you're already listed and already identified?
All of the cases deal with a claim of bad faith by State Farm in the manner in which it adjusted a wind or hail roof damage.
But those are other cases, not this case. Am I misreading Rule 26?
I wouldn't interpret it the same way you do, but we're getting to the issue of sharing. The reason, one, we're going to know this information. We're not going to be able to remove it from our heads. There's no need for us to go case by case by case to jump through the same hoops. The rule, I think, and there's been numerous sharing orders entered by various courts, some with a lot fewer restrictions that we have, but it seems to me that the issue of State Farm's revision of their policy on roof damage claims, that's going to be in every one of the cases. So the only question is, do we have to go every time and jump through all these hoops? Or in addition, how do we put this information out of our minds when we go to take a deposition or argue a motion in one of these other cases? So I don't think Rule 26 prohibits the sharing the narrow sharing that Judge Smithhart has allowed.
Mr. Wilson, can
Yes,
I kind of go back to piggyback on what Justice Mendham was talking about? He was talking about you sharing this with or adding your name as counsel in out-of-state cases. Does this order allow you then to add your name to pending cases in Alabama, other areas? This one's in Union Springs and Bullock County. Can you now, under this order, add your name to cases in Tallapoosa County that are pending or Madison County?
With all due respect, I don't view myself as ever, quote, adding myself to a case. If someone asks us to get involved, a lot of our work comes from referrals. And I think there's a lot of reasons other than the fact that we might have some documents that causes that to happen. So if I make an appearance in another case in Alabama, I will have the limitations in this order, but yes, we would be able to use these documents in those cases according to the way the order's written.
In cases that you might file in the future in Alabama, you would understand this order as allowing you to use these documents in those cases also.
I do. I think that Justice Mendham pointed out some ambiguity there, but I do think that, and it makes common sense. Because why would you reinvent the wheel? And as a practical matter, we have these documents. They're not going to disappear in the night. I mean, we're going to use the information that's provided there. The court, in coming up with this very narrow order, which contains many limitations, in essence, the court has allowed us to share the documents with ourselves.
Well, I'm concerned about, you're talking about the scope of limitations, about when one of the limitations is the documents have to be returned.
Yes, sir.
When this case is over with, right?
Yes, sir. And if this order applies in other cases, the same would be true.
So I'm a little confused. Like, this case might be over with. What about the other 8 or maybe the other 50 that have been filed in Alabama? If they're still going on, but this case is over with, do the documents get destroyed, or do you get to keep them until the last case, all the derivative cases and the children cases and the grandchildren cases get resolved?
We keep them, and this order is in effect the entire time.
Even though this case has reached final judgment,
Yes, sir.
you get to keep the documents.
To use in cases as limited by this court's order. Yes. And we would still be under the obligation to return the documents in the other cases. And that's provided for by the court. So I agree completely with you.
Let me follow up on that if you don't. Over here. Over here. Sorry. I get lost in the mix sometimes.
It was me that was lost.
Yeah, following up with Justice Cook, this order says within 35 days of the final determination of this action, each person shall be obligated to return these documents. So let's say you resolve the case tomorrow, but you got 10 other cases pending where you were planning to use this order to share. But doesn't that limit you? Doesn't that mean you still got to go through the hoops, as you say, in the other cases to be able to use these documents? Because you got to return them when this case is over, right?
The order provides that.
Could you?
Mr. Wilson, you need to speak into the microphone.
Yeah,
I'm having a hard time of hearing you.
Yeah.
That's unusual for me. Too loud. The order continues after the end of this particular Foor case, and the court retains jurisdiction for purposes of this order. So the order would still be in full force and effect, even though the Foor case ended. So it would continue to apply, and we would continue to have these strict obligations as to how we handle these documents.
Mr. Wilson, I appreciate the frustration of the other members of the court, so I just want to make sure that we're on the same page. Okay.
Yes, ma'am.
All right. The document says from Judge Smithart, within 35 days of the final determination of this action, you either return or destroy. Period. And that if you've given any information to other individuals within 7 days of the final determination of this action, you have to tell those other people that they also have a return and destruction obligation. None of that language sounds to me like you get to keep this. This action is over within 35 days, return or destroy.
This order, by the courts allowing us to use these documents in the other cases, continues in effect. It will govern
Mr. Wilson,
other.
so your position is you would not destroy or return these documents 35 days after the end of this action.
That's correct.
And you wouldn't be worried about being in contempt?
No, ma'am. Because, well, no, Your Honor, because the court clearly intends and has stated that this order will apply to all of the cases that he has allowed us to access these documents for, not merely the Foor case.
Mr. Wilson, it may apply to those, but you still have an order that says these documents have to be destroyed or returned within 35 days of the final determination of this action. To me, that's pretty clear. I don't know how you get around.
I cannot agree with you on that point, and here's why. The court has made this order apply to all of the cases. So therefore,
And I understand that it may apply to the other cases, but it clearly says in this order that these documents have to be returned within 35 days of the final determination of this case. It specifically says this action.
Mr. Wilson, all I can tell you as a former circuit court judge for 13 years, if the position you just took with I enter an order like this, you need to retain counsel for a contempt hearing.
Your Honor, I am glad to present this issue to Judge Smith-Hart and ask for some consideration of it. I'm just telling you what my interpretation would be.
We'll let him know you gave.
His might be different. His might well be different.
All right, can I change gears, Mr. Wilson?
Please. Yeah,
I
please.
welcome another thing. Your I guess petitioner's counsel has mentioned that federal judges Dinella and Proctor have looked at an order and have rejected that.
Right.
What weight should we give to that? I mean, consistency seems to be something important. How do we evaluate what federal judges have maybe done in a similar case or dissimilar case, and how that should impact on, is that just something that we can look as just some interesting authority? Is it persuasive, or what should we do with their actions and their comments about a similar order?
I certainly think that you should consider their comments, but what is occurring there is another trial judge has exercised his or her discretion and made a different decision from what Judge Smith-Hart did. That's not in and of itself an abuse of discretion. It's nowhere near abuse of discretion. The order that was presented to those two federal judges was the one that we offered, not the one that Judge Smith-Hart entered with all the restrictions that he put on us. So certainly there's policy issues in those two judges' comments that, of course, the court would consider. But you're not looking at the same order. That was a sharing order. And in a sharing order, you can send the documents to another attorney. The only restriction is that he have a similar case. State Farm would never know who had those documents, or if it were a true sharing order. Here, we will be present in any case in which these documents are used.
So this order is more restrictive than a sharing order?
Very more restrictive, totally restrictive. I mean, it allows us, the sharing provision allows us to share it with ourselves.
So I'm concerned about the government sharing
Yes.
provision, that you can give it to any government entity anywhere in the country without them asking or sending you a subpoena. Is that right?
To be quite honest, I have not focused as much on the government aspect of it as apparently some of you have, but I would think that, well, my client has already made a complaint with the insurance department. It didn't include any confidential information.
But it was the Alabama Department of Insurance.
Yes, yes.
It wasn't like the California Department of Insurance or the New York Department of Insurance, which I'm just guessing might be a little more hostile than the Alabama Department of Insurance.
Let me put it this way. I don't disagree with your concerns about the governmental issue. It's very, very broad. By its wording, it could be a regulator other than the insurance department of New York City or wherever. So,
And there's no
think that's a
restriction in
valid-
them using it, right? They don't have to agree to return it or destroy it, right?
oh, I certainly don't think that a governmental agency would have a responsibility to. I mean, they do their job. I don't think they'd have a responsibility to destroy anything that was provided to them. But
Even if you provided it to them? Even if you provided it to the insurance company, this order wouldn't apply to that? In that,
get back to my point I made earlier, my agreement with the other side. I don't know how it would work practically, but anybody that got these documents would be signing off and agreeing to do what's in this protective order. Whether you could force a regulatory body to do that, I'm uncertain, but
Wilson, why do you want the government sharing provision? Do you know why that's even in there at all?
well, as I always try to do, I try to be honest. I don't know. To be quite honest with you, I've focused on the issue of the other civil lawsuits.
We've discussed this before with opposing counsel. State Farm's the one that came up with the government.
That's
in their
right. It was
proposed
in
order.
both orders. It was in both orders.
So anyway, we can continue.
Doesn't seem to be in dispute. The only real dispute is whether we can share these documents with ourselves. And if someone asks us to get involved in another bad faith case, we're going to evaluate it just like we do any case that comes to us. If we think it's got merit, if we think it can be won, all the factors that go, jurisdiction, venue, amount of controversy, all of those things. So I don't believe there's a basis to be concerned about us trying to manipulate the system or this order and it just add our name to a case and never do anything else in it. That's just simply not going to happen. And one of the, why is the abuse of discretion standard what applies here? It's kind of like ori tennis, but not as strong, but the judge knows the lawyers that are appearing before him. That's one of the considerations he makes in deciding and crafting his order about what he's going to allow to be done with these documents. Our firm has a former bar president, and the two elder statements of the statement of the firm have over 101 years of experience, all with no blemish of any kind.
No one is questioning your ethics. So I think we want to make that clear. I mean, you are all very well-respected attorneys in the state of Alabama. We do not question your ethics.
Well, thank you very much. I'm not sure that State Farm shares your beliefs on that, but
Which that's probably right on point on this. I mean, I appreciate, and I think everyone's ethical, but as a very experienced and successful plaintiff's lawyer, apparently pursuing with some degree of success quite a number of RIT claims against State Farm, and us sitting here impartially, wouldn't you at least think, I suppose we should be somewhat sympathetic to the concern of State Farm, the insurance company, as a party, that perhaps they are taking a different view?
well, it does, of course, raise the issue of a larger set of people having access to those documents.
Mr. Wilson, your time is up. Thank you very much for
Thank you very much.
Ms. Rawls.
Thank you, Justice Wise. I also want to affirm on the record that this case is not about trust in counsel. It is about the structure of the order and what it allows. Even well-meaning attorneys can lose track of what has been shared where, particularly when, as we just heard, there's not even a clear understanding of what the order allows or doesn't allow. This case is also not about State Farm saying that lawyers have to forget what they have learned. It's about making sure that discovery is tied to each and every case. If plaintiffs learn about a document, a confidential document in this case, nothing about State Farm's position prevents it from simply asking another court for that document, and that court gets to make its own decision. An order should not make discovery. Yes.
I've got a couple questions. One, it's just back to the textual point I was bringing up with your friend on the other side. Rule 26B, any reason not to go full text on that? Or am I I assume you agree with my reading that 26B limits the scope of discovery to the case, pending case, that sort of thing. Any reason not to see the case through that prism?
I think that's exactly the correct perspective to take. I think this case rises and falls on Rule 26 in the text of that order. Yes, it does tie. And let me back up. We understand that each court has discretion over discovery matters, but that discretion is anchored to the claims, defenses, relevance, proportionality needs of that pending action.
Okay. I've also got a sort of a curveball for you relating to the jurisdiction of this court over the mandamus petition vis-a-vis the Court of Civil Appeals. So the Court of Civil Appeals, I believe, can hear cases, has exclusive appellate jurisdiction over cases involving where the amount of controversy is $50,000 or less than some slow threshold. And I guess my question is, how do we get to that threshold here? I think that if I remember right, the claim that was denied is in the $5,000 to $10,000 range. There may be a claim for mental anguish. There may be punitives. I could understand why the Foors would say this is more than $50,000, but curious if you agree that it's more than $50,000 case, or can you walk me through that, or do you need more time to think about it?
I will try my best. I will note at the outset, I'll urge the court not to focus too much on that issue. I don't think it, it needs to be resolved for purposes of today. On the face of the complaint, there is about a $4,800 difference between estimates. With potentially the pattern or practice allegations, it's possible. I think it's kind of to where we are right now in this case is discovery, and we're still learning the facts. So it's a little bit difficult to answer now. Something I do want to speak to is the risk of harm to State Farm. I understand on the other side, there might be this position that, well, other trial courts can just deal with this issue, deal with shared documents on the back end. For example, on an appeal or at the motion in limine stage. At that point, Alabama law requires the protection to be up front. By the time another court is handling a motion in limine, for example, State Farm's documents could have already been dispersed under this order to multiple other courts, to governmental agencies, seen or used by people that no one knows. And at that point, the court really would just be playing kind of Monday morning quarterback on a disclosure that has already happened, and the harm has already happened to State Farm. So that would not be a sufficient safeguard. I want to talk briefly, there was discussion about the return or destroy obligations. I understand in the text that it might appear to require downstream recipients to return or destroy, but there is no enforcement mechanism behind that. All plaintiffs' counsel have to do is tell others, quote, inform them about the case being over, remind them of their return or destroy obligations. But a requirement in the text is very, it's legally vulnerable for people downstream who have actually never had to receive a copy of the order or agree to be bound by it.
Well, the order appears to say, perhaps I'm reading this wrong, that they are obligated to return the same to State Farm. This is after the 35 days. They shall be obligated to return the same to State Farm, including any copies, or destroy such information and certify that it has been destroyed.
I would agree that that is applicable to plaintiffs' counsel in this case, but becomes very vulnerable. For example, if a Washington state attorney has received these materials, has never seen the protective order, hasn't agreed to be bound by it, that enforcement would not apply to that person. If there are no other questions for these reasons, State Farm asks that the court vacate the sharing order and direct entry of a non-sharing order. Thank you.
Thank you, Ms. Rawls. All right, we will take this case under submission. Thanks very much for everybody for your time, and thanks to all of you for sitting through the arguments and listening to what the attorneys had to say and the court.
All rise. The court is adjourned.